Joining us now, NBC News correspondent Yamiche Alcindor, live outside the Supreme Court in Washington. Catherine Christian, former assistant district attorney from the Manhattan DA's office. She is also an MSNBC legal analyst. And Dr. Kavita Patel, former White House policy director and MSNBC medical contributor. So, Yamiche, take us up to speed on what's happening there at the Supreme Court right now.
Well, right now, their oral arguments are underway in the significant abortion case. And really, this is coming down to whether or not federal law supersedes state law. In this case, of course, we're talking about Idaho's abortion ban. It says it only has exceptions when a woman's life is in danger. And it specifically says to prevent the death of the mother. Now, right now, we're hearing a number of questions, first from the liberal justices who are really zeroing in on this idea of the difference between a health risk versus a life-threatening risk. The justices really, Ketanji Brown Jackson, Elena Kagan, Justice Sotomayor, they all were pushing the lawyer for Idaho on this issue, saying, well, aren't there cases where a woman's health needs to be treated where she's not at death's door? And a number of times they pointed out, well, what about when a woman might lose her reproductive organs? The lawyer for Idaho at one point saying, well, there really isn't a case where your health is at risk, but your life isn't at risk. But I've talked to some doctors who say that's definitely the case. You have cases where women might have to have hysterectomies. They might have to have their fallopian tubes removed. That might impact their future fertility, but they might not be at death's door. So there's a real issue there. I also, though, just in the last few seconds was listening to Justice Alito, who's one of the conservative justices, and he was really pressuring on this idea of whether or not this Idaho law really does conflict with federal law. And he was in some ways leaning toward dealing with Idaho law as being the superseding here. Just listening to these arguments, it sounds as though the court is leaning toward saying that this federal law, EMTALA, that it supersedes Idaho law. Of course, this is a court you can't really predict what the court is going to decide. We're not going to hear that till later in the summer. But most of the justices, other than Alito that I've been hearing, have really been zeroing in on this idea that emergency care to stabilize a woman, if it requires an abortion, that likely is something that should be allowed.
Yeah, I mean, okay? Dr. Patel, this law only provides, and I'm just kind of digging into it, only provides an exception for the life of the mother. But the federal government's position is that in an emergency room, they got to provide care that preserves the health of a patient. How is that different?
Well, that's the point, I think, Jose, is that they're trying to keep with EMTALA, which is federal law, Emergency Medical Treatment and Labor Act, where we have an obligation that if someone needs to be stabilized and can't leave our emergency room or the hospital, that we are obliged to treat that patient. This has been in place for decades so that we didn't see patients getting dumped onto other hospitals and we didn't see care being infringed upon when you did need that medical stabilization. And I think that's where the judgment as a doctor comes in, Jose, that the life, as you heard, might not necessarily be at that moment someone who is going to die on your gurney in front of you, but that if you do not stabilize and take care of them, they could die.
And so stabilization oftentimes, or no, includes an abortion?
It could. And I think that's the issue, because you have to make sure that you're making an assessment about whether or not the fetus could compromise the life of the mother, could compromise future fertility. None of this is done without kind of a very real conversation between the doctor and the patient. And I think that's why all of us are a bit bewildered, because nobody is talking about the fact that this is going to be a judgment call by doctors, not by lawyers.
And it also has to occur in very difficult circumstances in difficult times. I don't know how many times doctors are able to have this level of conversation with a patient if they are in a critical state.
Right. And certainly you're trying to make sure we get consent from patients. We do everything we can to explain the situation to patients. But yes, there are plenty of times, not necessarily around an abortion, but plenty of times medically where stabilization and treatment involves making a judgment call where the patient might not even be conscious. But that's, I think, where, again, this is meant to be something, the federal law that's on the books that the administration is citing, this is really meant to be a way to allow for health care and for access. It was never intended to be directed or to be used as it is today about abortion.
And we're watching live pictures from right outside the Supreme Court, where we see protests on all sides of this issue being right now carried out. And there are, of course, speakers there just feet from the entrance to the Supreme Court. Catherine, talk to us about the legal debate that's going on here.
The reason why we're here, unbelievably, in 2024 discussing women's health, reproductive issues, is because the Supreme Court opened the door to this when they overturned Roe v. Wade and sent it back to the states. So now you're going to have this patchwork of different states having total bans. And this ban in Idaho is only for, as you said, rape or incest if you have a police report. And if you know anything about those crimes, and they are crimes, often the victims of those don't go to the police. So you're basically saying we don't believe you because you don't have a police report. Or in the event of a woman, if the woman might die. And as the doctor said, that's not often the case. There's a gamut of reproductive issues that women have, you know, along with, as what a reporter said, you know, ectopic pregnancy, miscarriage, fibroids. So that lawyers are discussing this is, you know, what the Supreme Court did. And legally, what the government is arguing is this federal law is just imposing a standard of care, an objective standard of care on Idaho and on these emergency rooms. So why are we even here?
What does the court option-wise have?
Well, it's hard to predict what's going to happen. You know, it's hard just because you hear what, you know, you heard, interestingly, most of the women on the court were asking, you know, being incredulous, what they're going to predict. They have the option of just saying, in this case, they're going to keep getting these cases. You know, federal law is just an objective standard of care. Idaho has to abide by it in these limited circumstances. Or, you know, it could be a different line. Remember, it's a majority conservative on the Supreme Court. That's how Roe v. Wade was overturned. So it's unclear, and we're still waiting for the decision on the other abortion case that was just a month ago. So it's a conundrum that the Supreme Court did themselves.
And how does, Dr. Patel, this federal law play a part in your practical day-to-day experience as a doctor?
Yeah, I think that this is exactly where now many doctors, for me, would be just a personal judgment call based on evidence, decades of experience. You now have to pause and think, do I need to consult or discuss this with administration or an attorney? And I think that's not part of our training. That's not what we were kind of trained to do. We're trained to treat the patient and to do what's in their best interest. So it puts a pause and it interjects an unnecessary entity and doubt in between that relationship.